Thank you very much. Again, my name is Alan. I am an attorney with Schulman, Lopez, Hofer, and Adelstein. We may represent some or many of all. If we do, great to see y'all. If not, still great to see you. Happy to be here and to hopefully share a little bit of information and some resources on your role as board members when it comes to discipline. Because we think about, for the most part, discipline. What does a board member have to do with student discipline? That's going to be your principals. That's going to be your deans of discipline or your assistant principals, whoever you have on your campus is handling that. But there are some roles that the board can eventually play if there is a particular challenge to a discipline decision, especially when it comes to expulsions. Our commissioners' rules, the rules that the Texas Education Agency and Commissioner Morath and all the other commissioners of education put out, there is a provision in there that notes that our board of directors, so y'all board members, you are the final stop for any type of complaint that comes in for the school. So whether that's an employee complaint, a student complaint, or a parent complaint, the buck stops with y'all essentially. And so every charter school needs to have a process in place that allows for individuals to appeal or to file a complaint or grievance of some sort. Now, of course, we can start it, have the initial complaint be considered by the principal or somebody else, and then have the superintendent or another C-suite executive, I guess we could say, kind of handle it. But ultimately, each of our schools needs to have a process by which any aggrieved party can go to the board of directors and kind of seek redress from y'all as members of the board. And so there are some things that y'all can kind of look out for on your end if you ever do receive an appeal or get an appeal of an expulsion decision. Just show of hands, any board members ever had an expulsion appeal before? One? Oh, okay, one. Yeah, so it can happen. We on our end, on the practice side of things, on the legal side, we are seeing more appeals of expulsion decisions over the past couple of years. Usually, or at least in the past, a lot of times folks would just kind of say, fine, we'll go somewhere else. But lately, we've had a lot more people wanting to challenge those decisions. Of course, you can understand that from the parent's point of view. Their child has been told they're no longer welcome in the school. They prefer for that not to happen. And so we are seeing an increase in the number of appeals that come through on the expulsion side or when it relates to student discipline. So again, a lot of this information may not really apply or be too practical for y'all necessarily in your role as board members, but we wanted to give you an overview of what the discipline process should look like so that if there ever is an appeal, y'all can kind of have a little checklist in your mind about these are the things that we should be looking for and considering in the event that we as board members are asked to kind of check the work of our administration and whether or not a particular disciplinary consequence was appropriate. Okay. Another reason why it's important for board members to understand a little bit about discipline is because the law tells us Chapter 12 of the Education Code tells us that each charter school must adopt a student code of conduct. The law says that each campus or the district as a whole can have it. I believe most charters just have a single code of conduct that applies to everybody, regardless of whatever campus they may be at. That seems to be a bit more consistent. Otherwise, you end up in situations where you could have wildly diverging consequences for the same type of offenses at different schools if you have different campus codes of conduct. So pretty much everybody that we work with, and I would imagine most everybody in the state, just has a single district level code of conduct that applies to all of your students, regardless of which campus they may be attending. And so once more, this is something the law tells us we must have. This code of conduct is a policy, and as board members, y'all have the final say on policy. And so it's up to you to approve these codes of conduct. What do we need to have in those codes of conduct? Well, we need to set out our standards for student behavior and conduct and identify those behaviors that we say, nope, we're not going to let that happen here in our school. That's not part of our values, and so we are not going to tolerate students who engage in certain types of behavior. We also need to let parents and students know what the potential penalties are if a child happens to violate our conduct standards. And so we can set out, here's the range of penalties from lunch detention, to come into school 5 minutes, 30 minutes early for a early morning detention, or in-school suspension, out-of-school suspension, whatever the case may be. And so we need to, again, kind of give parents and students some notice of what may happen if they happen to violate our code of conduct. And then the other thing that is incredibly important and that is legally required is that when we are going to be expelling a student, or if we are going to allow expulsions of students, our codes of conduct must include a due process procedure that needs to be followed before an expulsion can be finalized. And that is because the courts have essentially recognized that there is a legal right, there is a legal interest of a child to be able to have a free public education. And if we are going to be taking that right away and telling a child, you can no longer come receive a free education from our school, we have to give them due process before we take that right away from them. And so that's why this due process discussion in our handbooks or in our codes of conduct is very important, because again, the courts have told us we must tell parents and students the process by which we are going to take that right to get a free education from us away. So that is a very important thing for us to have in our codes of conduct. And so please, every time you review them or update them each year, please double check and make sure that you have this due process procedure outlined. And we'll talk more about what that process should look like here in a bit. Our codes of conduct also needs to kind of set out when we are going to be able to exercise jurisdiction over our students. We know that we cannot control our students, nor do we want to control them 24 hours a day, 7 days a week. We don't want to be all up in their business on what they're doing on a Friday night or a Saturday or even on a Tuesday night after school. Like, that's family time. They can do, let mom and dad take care of it there. But we do need to be clear about when it is that we can actually exercise authority over a student who has misbehaved in some way. Of course, that's going to include any sort of conduct that occurs at school or during school activities. And so if you're on a field trip or a band competition, whatever the case may be, if you're doing a school-related activity, yes, the school is going to have authority over them in the event that there is misconduct. There can be certain situations in which, if a student is outside of school and maybe not engaged in a school activity, if they engage in conduct that could be considered a felony, we may be able to take jurisdiction over that. Because again, we've seen instances where perhaps a student engages in an aggravated assault outside of school, or I've seen some instances where students are involved in armed robbery or things like that. So very serious potentially serious criminal offenses. In those circumstances, we may have the ability to take some action against them because we don't necessarily want to have a violent offender around other children or around our staff in some circumstances. So again, we need to be careful about that. If you run into a situation where you see an appeal of a student who's been expelled or disciplined for something that occurred outside of school, just be sure that you really do kind of get with your administration and the board meeting or during that appeal to get their reasons for why it is we decided to go that route. And then finally, another one that we often see is going to be online contact or conduct that occurs outside of the school setting. We have David's Law, which is our state's bullying law. Under that particular law, cyberbullying is included as a prohibited conduct by students, which can include, of course, bullying by computer or whatever it is, or any sort of cyber-type methods. And even if a student engages in that cyberbullying, and so if they're texting things or doing social media messaging or instant messaging outside of school, at home on the weekend or at night, if they bully someone from home or through these electronic devices, and that creates a disruption to our school environment, or if that creates a situation where the victim or the recipient of that bullying doesn't feel comfortable or feels like they're harassed, they're afraid that they're going to be, attacked or hurt or somehow otherwise injured or harmed at school, we have the authority under David's Law to go ahead and take disciplinary action over that. Because again, that's conduct away from school, but it's bleeding over into the school environment and creating a potentially hostile environment for the recipients of that conduct. So we can certainly take jurisdiction or punish a child or a student for engaging in that cyberbullying conduct, even though it happens outside of school. But for the most part, stuff that happens outside of school, we're not going to touch it because we don't want to, and that's not our role. Just briefly again, your codes of conduct can set out whatever type of penalties y'all would like. Now, reasonable penalties. We're not going to go back to the days when I was younger where you walked in the principal's office and there was the wiffle board, whatever, with the holes in it that they would use to swat. Like, we're not going to do that anymore. But we do have flexibility. We are not like a traditional school district when it comes to our disciplinary system. ISDs, they have a very rigid structure under Chapter 37 of the Education Code that they are required to follow. The law for ISD sets out very specific circumstances that will allow a child to be suspended, that will allow a child to be sent to an alternative school, or really limited situations in which a student can be expelled from a traditional ISD. As charters, again, we are not under those particular restrictions. We can make our code of conducts look however we want them to look, within reason, and so long as we are being fair and reasonable in how we assess our consequences. The only real limitation that we have as charters when it comes to our discipline, well, maybe I shouldn't say the only, but one of the only limitations that we have when it comes to disciplining is we are limited if we are going to be looking at issuing out-of-school suspension to a student who is homeless. There is a provision in Chapter 37 of the Education Code that applies to both school districts and charter schools that says we are not able to issue out-of-school suspension for a student who is homeless unless there's a drug offense, kind of a violent physical offense, or if there has been a weapon brought to school. So that particular part of the education code does apply to both charters and ISDs, but otherwise, the other disciplinary rules that apply to ISDs are not going to apply to us as charters. Once more, we follow our code of conduct. One big difference there that we see is ISDs are not able to suspend or issue out-of-school suspensions to a student who is in grade 2 or below. So young students, ISDs are not able to issue out-of-school suspensions for those students for the most part. As charter schools, we're not under that same limitation. Some schools have adopted that policy because they think, well, out-of-school suspension for a kindergartner, is that really effective? Or do we think our kindergartners are really going to engage in misconduct so serious that they should be sent home for 2 or 3 days? But again, that's a local decision for y'all. You can decide how it is you want your codes of conduct to work, and if there is any sort of age bracket that you'd like to see for how old a child must be before they're suspended. I have seen instances where, yes, schools will look to suspend or possibly expel a kindergartner or first or second grader. Unfortunately, we've seen situations where very young children like that are doing inappropriate touching or kind of sexual type acts against their classmates and things like that. And so if we have a very young child engaging in that, maybe we decide, yes, it is appropriate for us to issue those consequences. But again, some other schools will say, no, we're not going to go that way. We're just going to cap suspensions at grades 3 and up. But that's totally your call. We are not required to follow the education code for that. And the same thing goes with or for length of suspensions. A traditional school district cannot issue an out-of-school suspension for more than 3 days. That's their limit. Can't suspend for more than 3 days. As a charter, we have more flexibility. We can suspend a student for more than 3 days if that's allowed in our code of conduct. We'll talk a little bit about what those extended suspensions may look like. Once more, if we start telling a kid to stay away from school for 7, 8, 9 days, that's when the courts kind of tell us you need to have that due process hearing before you kick a child out of school for that long. But again, we have flexibility. I guess that was a very long-winded way of my saying that y'all have real flexibility when it comes to your codes of conduct. And you can make it look however you would like to reinforce the values that your school has and to kind of set up the discipline, the continuum of disciplinary options that you have. And if you want to limit those in any way based on the child's age or grade level or how long a particular punishment may last. But you have complete control over that, totally local decision. I'm not going to worry too much about this for y'all, but again, our administrators, they should be considering several factors when administering discipline. The age of the person involved, that can be a good factor. Intent, was there an intent to injure someone? Did a child pick up a backpack and swing it and knock somebody over the head? Or did they just have the bag on their shoulder and happen to turn around in the classroom and happen to bump another student who was sitting down in a chair? Like, was there intent there? That kind of stuff. And so there's all sorts of different factors that our administrations can consider when deciding what particular disciplinary action may be appropriate. And if there is ever an appeal of an expulsion decision to y'all as a board, you can certainly look at that or get information from your administration as to what factors they considered when deciding to make that decision. The other big thing for our schools and our administrators and campus staff to recognize is that if we have a student who is eligible for services or for special education services or for Section 504 services, so any students with a disability, qualifying disabilities, before we suspend them for more than 10 days during a school year or before we expel that student, there is a separate ARD committee process that must take place. It's called the Manifestation Determination Review. And that is a meeting where members of the ARD committee get together and look at the misconduct and kind of look at the child's qualifying disability as well and see, well, is this behavior linked or was it related to or substantially related to or caused by the child's disability. Essentially, the law tells us that we really shouldn't be disciplining students or expelling them for conduct that they simply can't control. So if you have a student who has a pretty severe emotional disturbance and is, if stress hits them, they may act out in violent ways, they may hit, they may kick, they may scratch, they might bite, things like that. And know that conduct is not okay. We don't want that in our schools, but there are some students who simply cannot control that behavior due to their disability. And the law tells us that we cannot be expelling those students for conduct they simply cannot control. So it is very important for our campus staff and our other folks involved in the disciplinary process at the beginning to go back and double check and make sure that anytime there's a recommendation for an expulsion, they're checking to see if that child received services under special education or Section 504. And if so, they need to do some other things on the ARD committee side of things before they actually finalize any disciplinary placement. And that could be something that would be shared with y'all on the board as well. Just a quick statement by the administration, no, this child is not qualify for eligibility, and so there was no need for the MDR, or they would say yes, there was an MDR, and so at least there you know that yes, the administration did what they were supposed to do before expelling. Okay. All right, investigations. I'm not going to go over this too much with y'all because you're not going to be the ones with the boots on the ground for the most part going on and checking this out. But again, it's very important that our administration does a thorough investigation. If we are going to be taking that right to come to school away, we have that burden of gathering evidence, and we have the burden of being able to demonstrate or explain and justify why it is that that child will not be coming back to our school system. It's also important that they develop a good record of what they did during this investigation process. That will help y'all on the board, because again, if there is an appeal, hopefully you would get a packet from the school or from the campus that says, okay, here's a brief little narrative about here's the background of what happened, the type of misconduct we think happened, and then they will provide to you a copy of the actual investigation reports. Copies of the documentation that was shared during the actual expulsion conference, which we'll talk about later. And so that way y'all have a record, again, a way for you to be able to kind of go through and check the work of the administration to make sure that things were done appropriately. And so you will have the ability to look at all the paperwork and make sure that the right process was followed. And then you can also kind of figure, well, was this an appropriate punishment? I will say that it's very rare for a board to overturn an expulsion decision, just because we normally recognize that your campus staff, your principals, your superintendents, they have a better grasp of what discipline should look like. But I have seen some instances where a board says, well, yeah, the child may have done this, but we think that's a bit too harsh. And so we're going to ask the administration to go back and maybe think about letting the child back in. Again, you're the board. As Dr. C mentioned, it's your school. You make decisions about the school in those meetings. And so if you feel like you need to change the disciplinary consequence, you have the authority to do that. Okay. Let's see. I guess that same record that I shared with y'all as a board, that is also something that could ultimately end up in court. Parents do have an option, if they would like, to actually file a lawsuit against a school if there is an expulsion decision, because again, that is a right for a child to attend school, and if we have taken that right away, parents can make constitutional claims against a school, claiming that we improperly took that right to attend school away. Those lawsuits are very rare, they don't happen very often, and in all honesty, the vast majority of those lawsuits are decided in favor of the school when it comes to the punishment. Like a judge is not going to substitute his or her judgment for your principals or whoever made that decision. They recognize that our school administrators, discipline is kind of their domain, and if they issue a consequence, it's very rare for them to come back and say, well, yeah, the child did violate your code of conduct, but it really shouldn't have been expulsion. You should have considered some other consequence. That's not going to happen. But what the courts will look at is, did the school follow the appropriate process in making that expulsion decision? And so that's where that record that's developed during the investigation comes into play. The witness statements, if there's security footage from a cafeteria or a gym or a hallway or a parking lot or whatever the case may be, making sure that we have that evidence. If there's text messages between the kids where they're arranging, hey, come meet me behind the locker room after school or whatever, those type of things. And so getting that information at the campus level is very important. It's important for y'all if there's ever an appeal, so you can again kind of check that work. And then it's also important in the off chance that a parent decides to file a lawsuit and challenge the school in that way. So that is something that y'all as a board certainly want to take into consideration if there ever is an appeal. Make sure that we have solid documentation that justifies our decision to take a particular disciplinary action. Okay. The other thing for our campus or our on-the-ground folks to consider is sometimes we need to be making reports to the authorities in particular circumstances. If a child comes to us or a student comes to somebody at the school and mentions that one of our staff members happens to have touched them in an inappropriate place, well, that's going to be a call to CPS or DFPS. That's a legal requirement. Each of our school employees, there is a legal obligation for them to make a call to DFPS within 48 hours of them having reason to believe that a child may have been abused or neglected. And so there may be circumstances where we get a report to something at school involving a child that we need to call Department of Family Protective Services or CPS. And then there's also instances when we may need to be calling the police or notifying law enforcement about certain conduct that occurs on campus. I'm going to go to this slide really quick. Don't need to see all this, but this comes directly from Chapter 37 of the Education Code. There's a provision there that says that any principal of any public primary or secondary school, so this applies to both principals at ISDs as well as principals of charter schools, but if any of these particular offenses happen to occur at school, or if we believe we have evidence that any of these offenses took place on school property, we have a legal obligation, the principal has a legal obligation to call the police and notify law enforcement about this. And these are the big offenses. Like this isn't, the child was walking down the hall chewing gum and tying their shoes at the same time, like the little ticky-tack stuff. This is the big stuff. Up here we got murder, deadly weapons, those type of things. And so of course, if we have a student bring a large knife or bring a handgun to school, yes, of course we're going to be calling the police. The ones that we see most often, or I think our schools see most often, are going to be drug-free zone offenses. So whenever children or students bring marijuana or other sorts of drugs onto school property or have them at school events, that is when we most often see these law enforcement reports. And then I guess the other one, sadly, that we see, probably the second most behind those drug offenses, are those terroristic threats, where for whatever reason a student decides it's going to be funny to start sending messages out that they're going to bring a bomb to school the next day, or they're going to bring a gun to school and start shooting people, things like that. Well, of course, if our campus learns that somebody's been threatening to bring a bomb or a gun or another weapon to school, the first thing we're going to do is be calling the police and let them know about it. So our principals are usually great about doing this, and just because, again, this is really serious stuff going on, and when we have this really serious stuff, we will be notifying the police. All right, so this is where y'all as a board potentially come in a little bit down the line. But what does this suspension and expulsion process look like? Well, if we're going to have a short-term suspension, so if we're just going to tell a student, well, you messed up, and so you're going to stay home for a day, or 2 days, or 3 days, however long is appropriate, we don't need to have that due process procedure in place for the short-term suspensions or disciplinary placements. We are not taking that child's right to come to school away at a permanent basis. We're just saying you need to stay home for a couple of days and think about what you've done, essentially. Or it's like, you need to go home because we're tired of dealing with you and we don't want you here for a couple of, we need a break. Maybe I shouldn't say it that way, but sometimes we think our principals may feel that way. So again, in those particular circumstances, we just get a report that a student did something that was in violation of code of conduct. Our principal, our assistant principal, whoever it is on the campus level that handles discipline does their investigation. And if they confirm that, yes, this particular violation occurred, all we really need to do is give the student a chance to give their side of the story, call them in for a quick meeting and let them explain what it is. We say, hey, look, we got this report. We've got this kind of stuff that says you did this. Tell us what happened. And then if the administrator decides that a suspension is appropriate, we just make that call then and say, okay, you're going to be suspended for X number of days. We put together a little written notice. Normally we call parents first too and tell them what's happening, but then send home a letter with the child or with the student that just says, Alan's going to be suspended for 2 days because he decided to hit his classmate up the side of the head or whatever it was that I decided to do. And that's pretty much it. We can offer a chance for the parent to have a conference with us, to come in and meet with the principal, to talk about what happened or kind of see if there's anything else going on. But that's really the only procedure that's required there for these short-term suspensions. And for the most part, y'all as board members aren't going to ever really hear about that. I can probably count on one hand in the 13 years I've been doing this that I've seen a parent try to appeal a 1 or 2 day suspension to a board. It has happened again just a very few number of times, but for the most part, there's really nothing that you can do about that either because the child was not taken out of school, they stayed home for a day or two, and then they were back. And so there's really not much that we can do on the back end of that. So pretty simple process for our short-term suspensions, and y'all as board members most likely will not be involved with that or need to worry about that very often. The other thing about here, are there any limits on the number of times a student can be suspended? Well, technically, no, unless the child is eligible for services for special education or Section 504 services. For a general education student, we can have as many suspensions as are necessary. And so I guess technically, Alan could get suspended for 35 days in particular school year. And that's, that could happen. Hopefully it doesn't. I was a better child than that in school. But again, there could be situations where we do have multiple suspensions. And if we do, that's legally okay because there's nothing in the law that says if a child continues to make mistakes or continues to violate our code of conduct, we can't send them home for a day or two at a time. As I mentioned, the only exception to that is going to be for those students who are eligible for Section 504 or special education services. Once we get to 10 days of removal during a school year, that's when that manifestation determination review process kicks in. And so if we're looking to continue adding more suspensions throughout the school year, we would have to have that MDR process before we actually implemented those additional suspensions above those 10 days during the year. Many of y'all have codes of conduct, or at least I guess many of y'all probably won't have circumstances where you get a student who has been suspended for 15, 20 plus days during a school year. Many of your codes of conduct include provisions that say if you are kind of a persistent or repetitive offender of our code of conduct, we can sometimes escalate that to an expulsion offense. You may have language that says, if you commit 3 level 2 offenses during a particular school year, we can then recommend you for expulsion. And so that's kind of how most charters will deal with that, rather than just having this pattern of suspensions over and over and over and over and over again. If we do reach a limit where we've had multiple infractions during the year, we can look to expel that student. We just need to be sure that if we do include that language in our codes of conduct, our administration is consistent in how they implement that. If we let one student end up with 25 days of suspension during the school year, continual repeat offender, always getting in trouble, but we don't expel them. But then if another student reaches their 4th offense during the school year and we automatically pull the hook on them and say, you're out of here, you're expelled, well, that could lead to a claim of discrimination by that student saying, you are disciplining me more harshly than these other children, and you are disciplining me more harshly because I happen to have a different skin tone, because I'm a different sex, or whatever the case may be. And so that consistency is always going to be key in how we implement those repetitive or persistent offenses throughout our school year. All right, so now we kind of turn to our extended suspensions and our expulsions. And I will say in our practice, most schools that we've dealt with have really just kind of done suspensions up to 5 days. A lot of times it seems like if they feel a child needs to be suspended for more than 5 days, we're probably going to look at an expulsion recommendation just because you're dealing with a very serious offense, and you'd rather, or at least a lot of times schools would just kind of rather go ahead and move towards an expulsion, since they would prefer not to have this super bad behavior, for lack of a better phrase, on campus. The important thing there I mentioned is those due process procedures. The law tells us that before we actually implement those long-term suspensions, which we kind of consider to be anything more than 5 days. So on our side, based on what the courts have said, anytime we have a suspension that's going to last more than 5 days, or anytime that we are recommending expulsion, we cannot issue a final decision, or we cannot actually issue that long-term suspension order or an expulsion order until we go through that due process procedure and give that child the hearing that they need in order to, or before we can take that action. So again, those hearings must take place before we actually implement that disciplinary consequence. One thing that y'all as board members can check on if there is ever an appeal, you can check on the actual notice that goes home. Wait, did I slip something here? Okay, sorry, yeah, this last bullet point here. When we give parents or notice about due process, we need to give specific notice of certain things about that expulsion process. And so we're going to be sending a letter home to the family that essentially lays out, here are the reasons for the expulsion and here's how the process is going to work. So this is something that requires more than just a phone call or a text message. This is something that we need to be giving written notice to our parents about our reasons for wanting to go ahead and do this expulsion or this long-term suspension. Now that written notice, again, these are things that y'all can check as board members if there's an appeal. You should get a copy of the actual expulsion notice letter that's sent home to the parent. And one of the most important things on that particular notice is going to be an explanation of why it is that we are recommending that disciplinary placement. The child has a right to know what we think they did. We can't just tell a parent, Alan violated our code of conduct and we're going to expel him. That's not sufficient. We need to give them some sort of notice about the actual conduct that we believe occurred. That doesn't mean that we need to prepare a 25-page written statement about everything that happens, but we should include just a sentence or two. Like in this particular example here, we just kind of mentioned, April 13th, John struck a classmate with his fist and used a binder to hit the student multiple times. So again, one sentence that says, this is what we think your child did. And then as part of that, we also need to identify the specific provisions in our code of conduct that we claim have been violated. We can't just leave it and say, he struck a classmate on his fist and used a binder to hit somebody. No, we need to go back and actually tie our code of conduct in and say that particular conduct is prohibited by our code of conduct as shown by this level 3 offense 8, which is an assault, or the level 3 offense 48, targeting another individual for bodily harm. So we need to give a little bit of specific information about which provisions in our code of conduct have been violated. And this is important because if we make it to a hearing and we go through the hearing and we find that there is not actually evidence to support this particular allegation or these allegations, but we find that maybe something else happened, well, we can't then go back and change our minds and say, well, we're not going to expel for these reasons listed on the notice, we're going to go back and pick something else. No, we can't do that because we haven't given the parent and the child notice that they may have violated that particular code of conduct provision. So if I'm John and I'm in this expulsion hearing and say, hey, look, I punched a classmate and I had a bag and whacked him inside the head, and it comes out in the hearing, maybe there's a video in the cafeteria where this supposedly happened, and the video clearly shows that no, it wasn't me, it was another student that did it. But that same video also shows me holding a knife, or that same video shows me smoking a cigarette or doing something like that. Well, we can't have that expulsion hearing and then have our hearing officer decide, well, Alan's not the one or John's not the one who assaulted his classmate, but he had the knife or he had the cigarette, and so now we're going to expel you for that. No, we can't do that because we did not notify the parent or the student that that was a reason that they could be expelled for this particular offense. So that is another thing that y'all can kind of check and make sure that whatever the expulsion decision was it actually identified in our expulsion hearing notice that went home to the parent. So that is very important, that notice that needs to go out. We also need to give parents information about where this expulsion hearing is going to take place, or where this due process hearing will occur. Give them the date, give them the time, give them the location of where it's going to be, just general stuff. Hey, we're going to meet 10 a.m. on Wednesday, whatever, at the school, wherever that's going to be. General practice is that we're going to have that expulsion hearing within 5 school days of the recommended expulsion or that recommended consequence. Once more, if we go over 5 days while we're keeping kids out, that's where the courts might tell us, you took too long to take care of this. Boards don't need to worry about this, but sometimes there may be circumstances where the parent simply can't meet on the day that we initially notice it, and so maybe we need to extend that period for a day or two, and so maybe it takes 6 days to the hearing. That's going to be okay, but we're not going to let this thing drag out for weeks. Sometimes parents will say, hey, I'm going to have my attorney there, and guess what? My attorney is completely booked for the next 3 months, and so you can't expel my child for 3 months until my attorney can be there. Well, we can say, well, no, that's not reasonable. We need to be able to be a bit more flexible, to act more quickly, so we can give some grace, but ultimately we can go ahead and proceed with that expulsion hearing because we need to take care of this. We can't leave these things hanging out there forever. We also need to inform the parents, and I guess I should also mention that these particular points are also things that should be included in our code of conduct as part of our expulsion process. And so our code of conduct should say that, yes, you're going to get written notice of the reasons for the expulsion. And then you're also going to get notice of the date, the time, the location of the hearing, and all that kind of fun stuff. We're also going to provide notice that the student has a right to be there at the hearing. Of course, yeah, if we're going to be taking this child's right to come to school away, they have a right to be there during that conference. We can't hold that expulsion hearing and say, nope, you can't come in this room, we're going to do this all on our own. That's not appropriate. The child can be there. The student has an opportunity to present evidence as well, and so they can tell their side of the story. We have to listen to them as well, or a hearing officer has to listen to the students and get information from them about what they believe happened and how they believe things happened. Perhaps it comes out that, yes, that last example that I had on the board where John did punch his classmate. But maybe John did that because his classmate came at him with a knife and he was, legitimate self-defense. And we may decide there, well, maybe it's not appropriate for us to be expelling John when he was really acting in self-defense. So these are things that we need to be prepared to listen to during that expulsion hearing to get the student side of the event. The student also has a right to be informed of the evidence that the school has related to that. And so it's not just we walk into the hearing and say, yeah, we think Alan violated the code of conduct and so we're going to expel. Well, no, we need to actually present our evidence. And this is something else that y'all as a board can consider. You may be given an audio copy of the expulsion conference, or maybe you listen to it during the meeting, or maybe you get notes of what was happening in the meeting where you can kind of read through and say, here's what was discussed and what happened, and here's where the administration actually presented their evidence. Remember, that record is very important. We need to actually create that record at the expulsion hearing level so that you as a board can possibly review, or if the parent ends up going to a court, the judge has something to review to know what was discussed during that hearing. Because once more, it's our burden as the school to present evidence showing why this right to an education should be taken away, or at least with respect to our school, and so we need to actually be sharing the information that we have. So again, if we have incident reports or witness statements, we can actually read those into the record and give copies of those to our hearing officer, whoever's making that decision. We would, at least, again, boards maybe not for y'all so much, but we of course redact that kind of stuff. And so if we have statements from 3 other students, we're going to redact the names of the other students under FERPA so that the parent is not seeing all the names of all the other kids that were involved. But again, we're still going to actually create a record where we verbally read or we verbally tell our hearing officer what happened and actually give them copies of the incident reports or the witness statements. There may be circumstances where we actually sit down and watch the video from the classroom or from the hallway or whatever it is to show that, yeah, it clearly shows that Alan did just walk up to his classmate and smack him upside the back of the head, whatever the case is. We can do that during these expulsion hearings, and it is very important for our campus administrators to be doing that, to actually create that record and show that, yes, we have evidence that your child violated our code of conduct. The parent also has a right to be present in that meeting. So we can't just say, okay, yeah, we're going to bring the student in, but mom and dad, you're not welcome. No, we can't say that. The student can be there, the parent can be there, and the family can also be represented by someone if they like. They could be represented by an attorney. Sometimes they're represented by a friend or a family member, and that's fine. They can have a representative there during that particular meeting. Let's see. During that hearing, I mentioned this one already, so I'll skip through it, but we actually present evidence by the school. Like, we present our evidence of what happened so that the parent and the student know what happens, and also so that we can develop that record in the event that there's going to be an appeal. The parent has the right to request copies of those records. Those would be FERPA records for their child, and so they can, of course, ask for those, and we would be able to provide those with appropriate redactions if other students are named or things like that. As I mentioned earlier, the parent or the student are also given an opportunity to share their side of the story. We will often see instances where the family wants to bring, another person in to be, a character witness, for lack of a better phrase. This isn't a criminal proceeding, it's not a court proceeding, so it's not really a character witness. But that's kind of what it is. I've seen several times when, a family wants to bring in a priest or a pastor or another religious leader to come in and talk about how involved the child has been or the student has been involved in church. And, he's been an altar boy since he was 7 years old or whatever it is, and these are all the things he's doing. Or another community member that's brought in, a coach on a community basketball team or volleyball team or whatever the case may be. And that's perfectly fine. They can bring someone else in to actually be a witness or talk about the child and the good things the child has done. As maybe a way to help us see, well, maybe expulsion may not be the best consequence. Again, that's their right. So we can allow them to do that. What we are not going to be doing, however, is allowing the parent to say, I want you to pull all these other kids who wrote these witness statements out of their class and come in here and let me talk to them and let me ask them questions. Well, no, we're not going to do that. We have our written witness statements, we have the other investigation records that we have, and we're going to use those documents. So again, we're not going to go and pull teachers out of class and make them, or subject them to being cross-examined by a parent about what happened, and we're not going to start pulling kids from classes to bring them into an expulsion hearing. So it's not a court proceeding. Again, it's not a court. There's not a judge there. There's not a court reporter. Nobody's put under oath, anything like that. And so it really is, the school has the chance to present their investigation file, and then the parent has the chance to explain or give the student side of the events. Then once we have that hearing, we need to issue a written expulsion decision or a written decision about what consequences may issue, if any. It's usually not best practice to announce that decision right when the hearing is done, because sometimes we do need to go back and actually look and check a few things to decide if we think there really is enough evidence to support a finding the code of conduct was violated. And then if you also think about it from the parent side, if you walk into that meeting, you give your side of the story, and then 2 seconds later, the school says, you're out of here, you're expelled. Well, that parent's going to feel like this was all kind of a sham, and you didn't really consider what we said. So we do need to be getting that written decision out, though, as soon as we can, generally within 48 hours or 2 school days, whichever is latest. So, a lot of times it's the next day. You take a night to think about it, and then the principal puts together, or whoever puts together that decision and provides that to the parent. And I mentioned a few seconds ago that this is not a criminal proceeding, and so when we are making our decisions, we are not looking to see whether we can prove beyond a reasonable doubt that the child violated our code of conduct. We don't have that high evidentiary standard. What we are looking for is there a preponderance of the evidence that the student violated our code of conduct, and is that particular provision in our code of conduct something that expulsion is allowed for? That may not be great grammar, but is that particular code of conduct offense something that is subject to expulsion? That preponderance standard is much lower than that beyond a reasonable doubt. That's just it's more likely than not that something happened. So we're looking to see 51% to 49%. Is it more likely than not that the student violated our code of conduct? And is that particular code of conduct provision something that is subject to expulsion under our code of conduct? I probably should have mentioned that earlier, but we have to be very clear in our code of conduct about what offenses may lead to expulsion. We can only expel for reasons that are listed as expellable in our code of conduct, if that makes sense. And so we can't just pick up anyone's situation and say, well, this instance, we think this is an expulsion offense. No, it needs to be specifically identified in our code of conduct as an expulsion offense. So that's something else that y'all can kind of check if there is an appeal, to double check and see, wait a minute, there's this particular offense that we were expelled for. Is this even something in our code of conduct that says the student can be expelled for it? Okay. That written decision, when it comes to expulsion, if we're going to expel, we need to say what the length is going to be. Most charter schools, or a lot of charter schools, will do permanent expulsions where it's not, again, I mentioned that charters and districts are different in that way. Chapter 37 tells school districts that there are time limitations for how long a student can be expelled. And once that time is expired, or once that expulsion period is completed, the district has to take that child back or bring them back into school. Well, charter schools are not under that same limitation. We have the ability to expel, and I hate this phrase, but everybody says it, but expel to the streets, just meaning that we expel from our system and they're not going to come back, or potentially. We don't have to bring them back into our charter school after a 60 or a 90-day period, or whatever the case may be. Some charters have set systems where they will allow for expulsions of different durations. Maybe they will say you'll be suspended through the end of the semester or through the end of the school year, and then potentially you can come back and try to reapply for admission for the next school year, the next semester, whatever the case may be. That's allowable, but just realize, or maybe you'd realize, that could create issues. As charters, many of you have adopted policies that say we are going to deny enrollment to a student who has a documented history of discipline problems. Well, a documented history of discipline problems would include an expulsion. And so we have the authority as charters to say, no, applicant who's wanting to come to our school, we checked your records and you have an expulsion from the last school you attended, we're not going to accept you. Well, if we have a student that we decide to expel, and then we tell them you can reapply for admission at the start of the next school year. So they reapply for admission, we check it out, we see there's an expulsion on our records, and then we write the parent back and say, congratulations, your child can't come to school because there's an expulsion on the record. Well, they're going to say, wait a minute, you told me in this hearing or in this letter that I could reapply for admission, and now you're telling me so I'm like, what's the point? Why did you tell me I could apply for a readmission, and then you just deny me outright from the beginning? So I think that's the reason why most charter schools don't expel for a shorter period of time, or set a time for the student to come back potentially. But again, that's a matter of local control. Your schools can set those policies up however you'd like. Just need to be sure that you're consistent. And so again, if you are allowing students to come back and start your school again after being expelled, you may have a difficult time in telling students from other school systems who have an expulsion on their record that they can't come and join our family and our school as well. So just kind of consistency things there. Something for the board to potentially consider when it comes to setting your policy, if you're even going to allow the opportunity for readmission or not. And then finally, this notice letter that we're going to be sending home after the hearing needs to outline the process for appealing the decision to the board of directors, or sometimes there will be an appeal. We have the principal makes the decision, we do an appeal to the superintendent, and then we do an appeal to the board. We can set up that appeal process however we want. It's just the last stop on the appeal process has to be to y'all as members of the board. And so we can just refer and say, yes, if you want to appeal, you must submit your written appeal to such and such a person within X number of days of receiving my decision. We often just go ahead and have the school go ahead and print out a copy of the code of conduct provisions that lay out the appeal process and include that with the letter. That way the parent has copies of that information as well. So those are the things that we need to include in those expulsion hearings. Again, are we going to expel? If not, is there going to be another consequence? Are we going to treat the 4 days the student was out pending the expulsion hearing? Is that going to be the consequence, where they were essentially suspended for 4 days, and then you'll come back to school on the next Monday or the next day, whatever the case is? And then outline the duration of the expulsion. Most of the time, it's just left open-ended and say you're going to be expelled, and that's it. We don't give a time frame for it to expire. And then just briefly outline that process for the parent to appeal the expulsion decision if they are so inclined. Some issues for our campus folks mainly, but what happens if a parent doesn't attend an expulsion hearing? We see that quite often where we give notice, we send a letter out, and then the parent or the student simply don't show. Well, the school has the authority, if we can document that yes, we actually gave notice of the hearing, we can proceed with that hearing, even if the parent is not present. Our obligation is not to have the parent and the student at the hearing. Our obligation is to give them notice of the hearing, to give them prior notice of the hearing. So again, the time, the date, the location where the meeting is going to be, and if we can document that, yes, we know the parent received that, and if they decline to participate, we can proceed because we have satisfied our obligation to simply provide notice of that hearing. In those situations, though, we still create a record of what happened, and so we would still have someone for administration go ahead and kind of walk the principal through what the investigation showed and be able to, again, create that record so that we can support our expulsion decision. Let's see. The other thing that we often see is what happens, or quite regularly, the parent is given notice of an expulsion hearing, and then they decide to pull their student out of school the next day, or they withdraw the child before that expulsion can take place. Kind of a, nanny, nanny, boo-boo, you can't catch me because I'm not your student anymore, those type of things. We have a couple of options, or our schools have a few options of those circumstances. Our least favorite, and the one that we recommend the absolute least, is to just process that withdrawal and then let it go and not to do anything else. Now, granted, sometimes we may decide, or I have had some schools decide to go that route just because, we're sick of this kid, we're sick of the parent, we don't want to see him anymore, the parent's sick of us, the parent hates us, and we just would rather just go ahead and separate and be done and never have to see them again. And sometimes that's a legit thing. We get that. The issue with that, though, is if we do not proceed, if we just process the withdrawal and do nothing else, well, we have parents who try to game the system where they withdraw, and then 2 weeks later, surprise, look who's just submitted an application for readmission, and now they're wanting to come back to our school. And if we do not have that expulsion hearing, if we don't have that expulsion on their disciplinary records, they don't have a disqualifying disciplinary history or a documented history of disciplinary offenses that would allow us to say, no, you can't come to our school because you have an expulsion on your record. And so that is always our least favorite option, is to just say, fine, withdraw, vaya con Dios, go away, don't ever come and talk to us again, because that can create some issues on the back end if the student tries to reapply for admission. The other option that we can have, which is a little bit more favored but still not our favorite, is to go ahead and just acknowledge that in writing to the parent and say, yes, we processed the withdrawal, but just be aware that there's still an expulsion recommendation pending. However, since you withdrawn, we are going to stay that expulsion hearing, so we're not going to move forward with that hearing right now, but in the event that you do try to re-enroll your child, we reserve the right to go ahead and issue another expulsion hearing notice, and we're going to pick up where we left off in the event that you try to bring your child back to us. So that's one thing that we can do. Our recommendation for the most part is always just go ahead and move forward with the expulsion hearing anyway. That just helps to tie things up and kind of close things up on the school end as well, because we have this recommendation out there. Again, normally if we've got an expulsion offense, that's a rather serious thing, and so we want to take care of it and make sure we've got it all closed up. If we have the hearing and we ultimately end up issuing that expulsion order, then we would still have that documented disciplinary history on the record, and so if the parent did try to come back, we can say, no, we're going to exclude your child from admission because of that disqualifying disciplinary history. And then it can also be a bit of a favor to the next school where the child may go. You kind of think about that, where if we potentially, maybe there was a student who did bring a gun to school or brought a knife or something else to school, a very dangerous weapon. And we notice the expulsion hearing and the parent withdraws the student the next day, and then we don't proceed. Well, the next school down the line would probably appreciate knowing that, hey, wait a minute, this student brought a gun to school, or this student brought a knife or another serious weapon to school. They would like to know about that so they can prepare. And you can kind of think about that for your school as well. If you are bringing new students in, I know your principals are going to want to know, did this student just leave the other school because she brought a gun to school or because she had a knife or things like that. Like the next school down the line is going to want to know those things. And so if we proceed and if we finish out that expulsion process, now granted, the student's actual official record may still just show withdrawal as the reason for moving out because the withdrawal happened first. Your PEMS people, your actual campus registrar people, they're the ones who can figure out how all those different codes for leavers works. It confuses me, but they'll be the ones to figure that out. But again, even if the student is coded as having withdrawn, we can still share with the next school system that, yeah, they withdrew, but they withdrew pending expulsion, and here's what happened as a result of that expulsion hearing. We do have an expulsion order on file, and then the receiving school can then at least know if they do happen to have a potentially dangerous or violent student coming their way. So that is why that's really our recommendation for the most part. If the student withdraws before the expulsion hearing, usually best is to go ahead and proceed with that hearing anyway. We absolutely still have jurisdiction to do that. Again, this is misconduct that occurred while the student was enrolled in our school. And so we absolutely have the authority to continue along with that disciplinary hearing, even if the student is withdrawn first. All right, appeals, this is where y'all come in. Again, either a student or a parent has the right to appeal an expulsion decision. If there is an appeal, we're not going to defer that disciplinary consequence. So if there's an expulsion order, we're not going to say, okay, if you file an appeal, we're going to readmit you back to the school and you're going to continue attending our school until the appeal is completed. Now that makes sense for us because we know that as boards of directors, you don't meet every day in meetings. You don't meet every week. You don't always necessarily meet every month either. And so there could be circumstances where we have an expulsion order and maybe it's going to be 6 weeks before your next board meeting. And so we're not going to get into a situation where we let that student come back and say, okay, you've appealed, so we're going to reinsert you back as a student and you're going to continue with this for 6 weeks or however long it is until the board meets again. That expulsion order still stands during the appeal, so the student would be expelled and would not be enrolled or attending schools with us pending that appeal. These appeals, when they're to the board of directors, those need to be considered during a public meeting. And so that would be a specific agenda item that we would need to add. Now we can do that in closed session. We can notice that as a closed session agenda item. There's 551.06. Oh goodness, I can't remember off the top of my head. There's like 081, 2 or something, but there's a couple of different provisions in the Open Opportunity Act that specifically identifies situations where we are dealing with student issues or we're dealing with appeals or the discipline of a student. And so we can notice that to be a closed session hearing. So we don't necessarily have to be giving the dirty laundry about the student and what they may have done in school in open session, but we would have to consider that in a board meeting. And then, of course, even if we do consider it in closed session before the board actually makes the final decision, we would come back into open session, take your vote there, and make sure that any decision would be announced during open session. So we're not going to take action during that executive session. We'll consider the appeal, you deliberate, and then you come back into open session, do your votes, take your action there. And then at least as far as the school is concerned or a code of conduct is concerned, once the board makes a decision on the appeal, that's it. No more appeals on the school side. Like you're the final say, the buck stops with the board, and so whatever you say, that's going to be the final decision. Now granted, the parent still has the right, if they're upset, they can try to file a lawsuit. Maybe they end up filing a complaint to TEA, but for the most part, TEA is also not going to come back and second guess your disciplinary decisions as a school. They may just look and see, just show us that you actually had an expulsion hearing and that you considered it at a board meeting if there was an appeal. And so they may ask for that. But yeah, the commissioner or TEA, they're not going to come back and say, no, you shouldn't expel. That's more of a suspension. Again, that's not their role. They're there just to kind of double check the process. Or perhaps the parent files a complaint to OCR. We see that pretty regularly where they claim, yeah, you're disciplining students who look like mine more harshly than other students who look differently or things like that. But again, OCR is not going to come back and substitute their judgment for yours as to whether or not that expulsion was an appropriate decision. So really, for all intents and purposes, once the board is done with it, it's done. There's no more appeals available through the school system. All right, special considerations. There may be circumstances where we need to kind of remove a student from school before we can possibly have an expulsion hearing or a long-term suspension. Maybe a student did bring a gun to school, or maybe a student did bring a knife to school, or a student really, really, really seriously injured another student, beat them down at school, things like that. Well, in those instances, if there's a health or a safety threat, well, yeah, we can tell that student, no, you brought a gun to school. You're not coming back to school for right now. You're going to have to go home and stay for a while because we need to protect the safety of everybody else here. And so in those emergency type situations, we may have a short term, or we may have an emergency suspension that lasts more than 4 or 5 days. Just the important thing is we cannot continue that indefinitely, and we cannot make that a permanent placement until we have that actual expulsion conference. So we have flexibility in emergency or health and safety situations to kind of keep students out of school pending a hearing or while we investigate. But again, we cannot make that a permanent final decision until we actually notice that expulsion hearing and give them a chance to go through that due process procedure. I've already mentioned special education, section 504. We're not going to do that again. Just remember manifestation determination review. All right, David's Law and bullying. This is something else where there was an update a few months back from TEA. During the 2021 legislative session, so 2 years ago, the legislature told TEA, you need to publish these minimum standards for bullying prevention. So these are things that TEA says that all schools need to do. Again, that was something that TEA was told to do back in 2021, and it took them until early 2023 to actually issue those things. So it took them nearly 2 years after the legislature told them to get their stuff together and do it to actually happen. There will be some impact to y'all as boards because this will affect some of your policies when it comes to discipline. But specifically for bullying and under David's Law, we are going to have to be incorporating some specific integrated instruction. So that's going to be actual curriculum materials that address matters related to bullying. And this is going to be kind of broken down by age level. For our early primary students, we're going to have to give direct instruction on how students or how children can recognize bullying, including what cyberbullying looks like, and then let them know the school's process for reporting bullying. So again, actual instruction during the school day on what bullying looks like, how can I respond to it, and who should I report it to. We need to be providing this age-appropriate instruction on how students or how classmates should intervene if they happen to see bullying. And so hopefully that means we don't teach kids that you see a bully, you just walk up and start punching them or beating them down. No, it's not appropriate, but teach them appropriate ways to intervene in the event they see bullying. And then also, we need to be reinforcing to students that, again, just because, if a kindergartner or a second grader engages in bullying one time, that does not mean that they are forever and always a bully. Things can change, people can change. These are young children just developing, their brains are going to change, all that kind of fun stuff. And so we should be telling our kids that just because somebody's a bully now doesn't mean they're bad. We should shun them and kick them out of our tribe and we will never talk to them again and stuff like that. Well, no, this is a behavior and behaviors can change and we can help change those behaviors by being good peers and things like that. For our secondary students, kind of the same deal, a lot of the same things, but just in more detail. We almost get to play neuroscientists with them because we're going to start talking about neuroplasticity of the brain. So again, developing brains, students, children, young adults, adolescents, your brain is changing, your chemistry is changing your brain, that kind of stuff. And so we're going to talk about that and kind of help kids again understand that just because somebody does something bad or bullies somebody on one occasion doesn't mean they are forever and always a bully. They can change, we can help them make that positive change, things like that. We are also going to be needing to put together age-appropriate surveys for our students. We are still waiting for a little bit of final guidance from TE on what those surveys look like. But we're going to be doing bullying surveys for all of our students, regardless of their age or grade level. So we're going to be asking them most likely, do they understand what bullying is? Can you tell us, do you recognize the signs of bullying or what bullying could look like? We're likely going to be asking them, do you know how to report? So questions about, can you tell us how to report bullying? So do they know what our policies are? Things like that. So we need to have these surveys in place, say during this coming school year, and begin considering those and, collecting them, and then kind of have a team that reviews those surveys to decide if there's any updates or things we need to do in our policy or procedures to help students understand more what bullying may look like, or if we can make clearer how it is that students should be reporting bullying in the event it occurs. We're going to have to set campus committees, and so we're going to get a committee at each campus that deals specifically with issues related to bullying. This committee needs to include parents, and if we happen to serve secondary grade levels at this particular school, we're going to have to include some secondary students as members of that committee. And that committee will again kind of be formed to help us, or to help shepherd what our policies and procedures with respect to bullying are going to look like and kind of help us know what type of programs we're going to put into place. So these committees are going to be new. Again, I don't think we've ever had this particular committee. where we're going to have parents and some of our older students actually be on these committees to address bullying. I need to have our policy for reporting. You already have reporting policies. I think most of you already have that. That's been in David's law since it was initially passed. Have to have policies in place, and so we still have those same requirements. Need to make sure that we have a process for students to report bullying. When it comes to students, we also need to be able to accept anonymous reports, so we can't require everybody to give us their name whenever a report comes in or whenever they file, but we need to have our reporting process in order. And then we also need to be incorporating these research-based interventions or supports. In the event that someone is bullied, what type of research-based interventions can we use to help that student feel welcome a bit again, to feel safe at school, to help kind of remediate whatever effects they may be experiencing from that bullying, and then also kind of take into consideration interventions for the possible bully. What are potential consequences? What are things that we can do, whether it's more social emotional learning type exercises or extra counseling or different things like that, where we can help the student realize this is not the way that I should be treating my peers or treating other students or other children. All right, almost done. We're going to have a rubric that kind of walks people through what bullying is. I believe that most every school in Texas, the Texas School Safety Center from Texas State University, has a very good checklist that tracks the definition specifically of what bullying is under the law. Whenever somebody asks me for a checklist, I always just send them that exact thing, because why reinvent the wheel there? It's a great little form. It tracks specifically what the law says as far as the definition of bullying. The new thing that we're going to have to do now is put together a bit of a rubric where we can internally track that we are actually investigating reports of bullying. And so it's almost like a checklist for the school, so we can go back and kind of check and see, okay, we received a bullying report on this particular date, then we need to go back and cross-reference and have a record somewhere that shows what we did in response to that report. And so that new kind of tracking rubric, that's going to be new. I think a lot of schools were doing that anyway, just internally, so that things didn't fall through the crack. But again, now this is actually part of the regulations applicable to charters and to other schools, where we do need to have that internal tracking mechanism. And then we'll have opportunities, or we're going to have to be able to go through sometimes and review those surveys, or not surveys, but those trackers, and kind of, self-report on ourselves to see if we need to kind of clean things up, or if we're responding in an appropriate time frame, and all that kind of fun stuff. And then in the event that we do happen to have a student who is eligible under special education or Section 504, if a student eligible for those things happens to be engaged in bullying conduct, well, we have to remember that there are certain protections for them on the disciplinary side, and we have to always follow that manifestation termination review process before we actually take any extended action against those students.